Hello and welcome back to the OCO Roundtable podcast. From Orare Company Advocates, my name is Melanie Mwenda. I'm an associate in the firm and we're excited to have you join us again. This is part 2 of our deep dive into the world of trademarks. If you missed the first episode, we unpacked what qualifies as a trademark, why they matter to your business and brand. In today's episode, we're shifting gears and connecting theory to the practice. We'll walk through real-world case studies that breathe life into the legal concept we discussed earlier. I'm joined once again by my colleagues from the firm's intellectual property practice group, John Mbaluto, Claire Mwangi, Wambui Mwariri, and Blenda Nyahoro. Karibuni sana.
Thank you.
Thank you, ma'am.
John, let's start with you. Having practiced law for nearly 2 decades, you've had a front row seat to how trademark law has evolved. Could you share some landmark cases you come across and what key takeaways our listeners can draw from them?
Yeah, so Melanie, thanks for that. I hadn't realized I'd been practicing for that long. I certainly feel quite old if I'm now being told I've been practicing in decades. But yeah, happy to be here and to share a few insights in terms of case law. So a couple of cases come to mind which I'd be happy to take the audience through. So the first case that comes to mind is the case of Weetabix. And in this case, it involved 2 parties, the applicant being Manji Food Industries, which sought to register Multibix for biscuits under Class 30. The opponent was Weetabix Limited. And Weetabix, as you all know, is I'd say a famous cereal that I think at one stage in our lives we all partook in. And I personally still take Weetabix until today. So what Weetabix were contending in this case was that there was a similarity or likelihood of confusion with Weetabix. And they also said that Weetabix is a well-known mark that was deserving of enhanced protection under Section 15A of the Trademarks Act. There was also an allegation of bad faith that Multibix will be riding on the reputation of Weetabix. In support of these contentions, Weetabix said that it had been sold worldwide, not just in Kenya, but across the world. And in Kenya, that it had been in existence for over 30 years. They said that the suffix Bix was a mark of distinctiveness. And it was part of the Weetabix brand, and anything that had the suffix Bix was deemed to be associated to that brand. So that Kenyan consumers, if they saw Multibix, they would then think that it was yet another brand or Weetabix product. So, in effect, they were saying that if a consumer went out there and bought Multibix, they would be thinking they were buying something that was actually a Weetabix product. And so what did Multibix say when they were contended with these allegations? First, they said Multibix itself is distinct, that the packaging and product category is different, whereas Weetabix was a cereal, Multibix was a biscuit. And they said in that case, there was little likelihood that people would get confused. They also denied any allegations of bad faith. So when the registrar sat down and eventually came up with his decision, this is what he said. He said that Multibix is actually substantially, deceptively, and confusingly similar to Weetabix, and therefore there was a real likelihood that people out there in the market would pick up Multibix thinking that it was yet another Weetabix product. He found this particularly because both products fell within the same class, Class 30, and therefore there was an overlap in terms of these products with cereals, biscuits, and flour products all falling within the same category, which is Class 30. So the registrar also found that the standard of care or cautiousness among consumers who buy everyday products is not very high, that they are not as cautious, and therefore there was a real likelihood of these goods getting mixed up. He also found that the suffix Bix was actually strongly associated with Weetabix products, and they were therefore deserving of wider protection of that particular suffix. In the end, Multibix's application was refused for reason that it would actually cause deception or confusion, and it would take unfair advantage of Weetabix's reputation and goodwill that had been built.
You know, John, it's only until you discussed that case that I came to learn that that's the reason why Multibix disappeared from the market, because I was a consumer of Multibix that actually preferred with Multibix products to Weetabix products. It was in a red package and the biscuits layered in that I really, really loved. And I could go to every aisle, every different supermarkets wondering why this product is no longer there. So it's actually sad that a good product can disappear from the market just because of a name. And so maybe this is even a lesson to business owners to really think through their names, because otherwise a product that is loved by many and has prospects for making sales for them could be deterred by virtue of just a name that is not distinctive, as you have discussed.
Sure, yeah. So two things. I think probably they should have used you as a witness to say how good the product was.
See, bad, is there limitation working against them?
Yeah. But then number two is that, look, if the product was that good, I think they should have simply said, fine, we can repackage it or rebrand it in a way that doesn't infringe on Weetabix, so that the people who like the product, such as you, would continue enjoying it, but under a different brand that doesn't infringe on someone else's trademark. So the other case that is of interest and I'd love to share is the one I call the Kenya Boys Choir case. And this case concerned one Joseph Muyale Inzai, who was the proprietor of a trademark called Kenya Boys Choir. And it was registered under classes 16 and 41, which relates to music and choirs. Now, another group called Kenyan Boys, remember the one by Muyale is called Kenya Boys Choir. Another group called Kenyan Boys Choir filed an application for expungement of this trademark, claiming that they were the ones who are the rightful proprietors of that name, Kenyan Boys Choir. They said that they'd been, since their days in high schools, they're all in Aquinas High School, by the way, which is a school I very well know. I used to go up against them in basketball. Very good in basketball, but apparently also good in singing. So they say that they were actually the true owners and beneficiaries of that name, Kenyan Boys Choirs, and that actually built up goodwill under that name since 1997, both in Kenya and abroad, including the US, where they had actually toured. And they were saying that the proprietor, Mr. Muyale, had actually used this mark to take unfair advantage of them and ride on their goodwill and reputation. They had actually also gone ahead and registered under the Business Names Act, their entity, what was called Kenyan Boys Choir, and an alternative, the Boys Choir of Kenya. And therefore, they said, similar to the Weetabix case, which I had talked about, there'd be a likelihood of confusion or deception in the market. What did Mr. Muyale say in his defense? He said that he's the one who founded this choir, that he was actually the choir master back in high school. And therefore, this is a case of a choir master going against his own choir. And he said that for these choir members were mere, contractees, if I can call them that there was a contract that was in place, and that they did not, as members of the choir, own the IP rights in the name of the choir. He also said that they were late. They had what we lawyers like saying latches, that slept on their rights, and they only started opposing once he had registered. And they had wondered where they were all this time. So this matter again ended up before the registrar, and certain legal issues arose. Number one was whether the proprietor, Mr. Muyale, had a valid and legal claim in the mark Kenya Boys Choir before registration. And the registrar also considered whether the applicants, which is now the boys, were considered aggrieved persons under Section 35 of the Act. So in the analysis, this is what the registrar found. He found that the names Kenya Boys Choir and Kenyan Boys Choir are virtually identical. He said they are phonetically, visually, and conceptually alike, and the only difference is the letter N. He also said that the goods and services were of the same character. They both engage in singing, in choir performances, and they target the same audience or customers. There is therefore a likelihood of confusion. He also found that the name Kenya has a national appeal, and it is not fair that one individual should be assigned the right to use that name. He also found that the applicants, this being the boys, had been using this name under the brand Kenyan Boys Choir, and that they would suffer limitation of their rights because of Mr. Muyale's registration, which would then block their use of the name. Ultimately, the registrar found that Mr. Muyale's trademark had been registered without sufficient cause and in error, and the same was therefore expunged. I think the key takeaway from this case is that ownership is not dependent merely on registration, but one has to show actual use and goodwill that has built up in addition to the registration. So even if somebody registered a mark first, it can actually be challenged and actually removed or expunged, as happened in this case. So it is important to note that it is not just a sprint or a dash to the line, such as the first person who gets across in terms of registration wins. No, you actually have to show use as well as actual entitlement to the name, especially if challenged.
John, do you think Kenyan Boys Choir then had an uphill task because they were relying on protection of a trademark through use? And if only they had registered it, then a search would have shown that they would have been saved all this trouble and the resources they had to expend to demonstrate what they did.
Absolutely. I think registration certainly aids. It aids in terms of protecting your rights. But the case here is that registration alone without use then does not aid a person who's not entitled. So Mr. Muyale did the registration, but ultimately was found fine. You registered, but you're not the actual user. Whereas the boys, had they registered, would have had a much easier time in terms of fending off or asserting their rights. So I think both use and registration is what is an effective combination in terms of asserting rights to trademark.
And I think, like you say, maybe that's the reason why the validity of a trademark is 10 years. So that then if you registered this mark and have not been
using it, precisely.
Can use that.
Precisely. So the next case that is of interest and I'd like to share with the listeners is the Sony case. And this, unlike the other two cases, was actually a case that was determined by the High Court on appeal from the registrar's decision. So if you go to the registrar and have opposition proceedings before the registrar, any party dissatisfied with the registrar's decision can appeal to the High Court. So in this case, the appellant was Sony Corporation, who are the owners of the Sony mark. I think we all know the Sony because of the music industry and their work there. And the respondent was Sony Holdings, which was the entity that had applied to register Sony Holdings as a word and device mark. So in order to set aside a registrar's decision, one has to show that this decision was wrong in a material way. The exercise of the discretion by the registrar was unreasonable, and that no reasonable tribunal would have arrived at that same decision that the registrar made. And the appeal before the High Court is in the nature of a rehearing or a reassessment of the facts. So it's a fresh evaluation per se. So in this case, the respondent, that Sony Holdings, had filed that name for registration in multiple classes. And Sony Corporation was opposed to the same and had taken out these opposition proceedings before the registrar, but the registrar dismissed the opposition and therefore allowed Sony Holdings registration. On appeal, this is what the judge, Justice Stewart, isolated as issues. Number one, he asked, is the brand name Sony well known in Kenya? Is the name Sony Holdings so similar to Sony as to lead to confusion within the market? And did the respondent, that is Sony Holdings, have a valid claim to the ownership of that mark? And he also asked himself whether there had been honest concurrent use or acquiescence by Sony to Sony Holdings registration of this mark or use of this name Sony Holdings. So in analyzing this, the court actually surprisingly found that the name Sony was not well known in Kenya. And so that you might find surprising. And I can see the looks of perplexion across the table, like, how do you not know Sony? But what the judge says, it's not enough for you to leave it to the judge to impute or infer from his own personal knowledge. He said you have to prove. And no matter how compelling you think your case is, you still have an obligation to discharge the burden of proof. And in this case, he found that Sony Corporation had not shown that they are well known in Kenya. And that's the other thing, that trademark is a territorial concept. It doesn't matter whether you're known in US or in China or in Europe. When you're here in Kenya asserting your trademarks rights, what you have to show is being well known, at least in this context, in the Kenyan Republic, the four corners of our country. So it is not sufficient that you're generally well known out there. The issue is, are you known in Kenya? And you need to lead evidence in that regard. And in this case, Judge Stewart found that Sony Corporation had not shown that they are well known in Kenya. He, however, found that because there were overlapping classes, there was still a likelihood of confusion because the goods and services in those overlapping classes targeted the same market and were similar. And therefore, Sony Holdings application in those classes which overlap was disallowed, whereas in the classes that there was no overlapping, the registration was allowed to proceed. So this case was partially successful. with some being allowed and some being disallowed. So what are the key takeaways from this case? So number one is that being well known requires more than just repute or fame. You must actually show to the standards required in law. And in this case, it's called a balance of probabilities. So evidence must be led, and that evidence must be credible. You need to be able to show maybe local promotions, advertisements, actual sales, and public recognitions. Call some witnesses and let the witnesses say how well they know the brand. Also, that there's nothing that prevents users of similar trademarks by different proprietors as long as the goods and services are different or under different descriptions or classes. So that if the goods are completely different, the likelihood of confusion then does not arise. Again, the court, when considering whether there's a possibility of confusion, looks at the ordinary consumer. So it's a person who is neither too discerning nor too careless. And we'll look at a standard soon enough in a very interesting case that is one of my favorite. And then the issue of acquiescence. Yeah, so the court in this case said that sometimes you can actually acquiesce to somebody else's use of your mark. But in this case, because there was no proof of use by Sony in Kenya, he said that the issue of acquiescence then cannot arise. So I think you can have a good case. I think this just shows sometimes you can have a good case, but if you prosecute it poorly, then even a good case can be lost. And that's what I would say in this case for Sony Corporation. And the judge said, surely, it is not for me to decide for myself whether I know Sony. It is for you as Sony to prove that you are well known.
Well, John, for me in particular, the Sony case was very surprising when it passed you read it, because I read it from the headspace of Sony. Everybody knows Sony. TVs, DVDs, Sony has been in our lives forever. But the more you read it, the emphasis is on proof, because even the judge themselves, do they really qualify as the ordinary consumer in that situation? You might be in your own sector of society that relates so much with this particular trademark that for you it seems obvious. But that necessity to bring physical proof to court becomes so necessary because you'd never be able to establish what the neutral ordinary person knows.
Yeah, that's quite right. And I think it shows sometimes how difficult it is to judge a case, because who knows, even this judge possibly has a Sony TV in his house, but he has to deliberately divorce himself as a person and sit as a judge and be very neutral and objective and say, has Sony in this case, as has been presented before me, has it discharged the burden of proof? And he found that they hadn't. And actually, not just him, he said even before the registrar, the same case had happened. I think it was a lesson learned by Sony as to how to prosecute a case. And certain themes cut across all types of cases, which is that you have he who alleges must prove, and you have to discharge your burden.
And this burden of proof, it can further infringe an entity's, Sony in this case, trade secrets. If I'm supposed to demonstrate that I am well known, and so in one of the ways I do is give you the sales.
Yes.
So it means I'm showing you who my customer is. A customer may is a trade secret. I don't want to tell you who I sell to. Then my IP, in terms of how I am able to make sense, is then exposed to the general public, not just to the opponent here, but everybody can read and see, oh, this is how Sony makes money. These are the people they're selling to. These are their interactions.
Well, I appreciate that, but I still feel that there are ways that you can still show being well known in Kenya without necessarily compromising on your trade secrets. So, for instance, what about tax remittances? So, if you're pushing a lot of product, what are you doing? You're also paying a lot to KRA. So, there are ways that you can anonymize this data. I just feel Sony, with the Sony Corporation, that is, not Sony Holdings, with a better, well, let me not castigate the advice they had, but this case there would have been a different outcome had it been better handled.
That brings us to the end of this episode of the OCO Roundtable podcast. We've examined how our courts are interpreting and enforcing trademark rights locally. We invite you to join us in the next episode, where we'll take the discussion global as we explore international case law and how the internet is reshaping the way trademarks are protected across borders. As always, if you'd like to learn more about intellectual property or other areas of law, we invite you to listen to more of this and other episodes by visiting our website at www.oraro.co.ke. We value your feedback. And therefore, we encourage you to reach out to us on our social media handles using the hashtag OCO Roundtable. Until then, goodbye and take care.